Good morning.
Good morning.
Anything before the jury comes?
I'm from the state, Your Honor.
Okay, you may bring them on.
Your Honor, you may recall, the day before yesterday, Al Brown was in the cross-examination by Mr. Savage when we adjourned for the day. We brought him back this morning for the show.
Come on, Mr. Brown. Come forward. Maybe you'll wait there until the jurors, maybe just wait right there inside the rail until the jurors come in. So what stage are we with Mr. Brown?
I believe Mr. Savage was still in this cross-examination.
First go around or the second go around?
First go around.
Very good. Good morning. Morning. Welcome back. Mr. Brown, resume your, please be re-sworn. Thank you.
You swear affirm the testimony you shall give the court and the jury in the trial of this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Brown, you're still under oath, but we've re-sworn you since you weren't here yesterday. Undergoing cross-examination, you may continue, Mr. Savage.
Good morning, Judge.
Good morning.
Good morning, Brian.
Morning, sir.
Just to review and get us sort of back in the flow of where we were the other day, you were the senior crime scene investigator in the case involving the death of Mr. Scott, is that correct?
Yes, sir.
And you arrived at the incident site a little after noon that day, is that correct?
Yes, sir.
And you were the guy who was in charge of the gathering of evidence that day.
Yes, sir.
And if North Charleston Police or any other agency did anything, it came under your direction of what to gather, what not to gather. Is that correct?
Correct. Obviously, information should have been shared or would have been shared.
And you had some basic information that there had been a police shooting of an individual following a traffic stop.
Now, basically, kind of like a radar, if you will. It sends out a signal, and as it hits the reference points, it's sending that information back to that, and then when you get to the final process, you'll have what you essentially feel like you're walking through a scene. You could see as if you were walking through and get measurements extrapolated from that information in the final processing.
So if this was presented to the jury, they could walk through the scene themselves, a virtual scene?
It's capable of that.
And the jury would be able to look at the same view that Officer Slager had that morning.
That should be possible, I would think.
They could actually look through the virtual eyes of Officer Slager at the time of the shooting.
I would say that's certainly possible, yes, sir.
And that would be a good thing to offer the jury for their analysis.
I would believe so.
It would also give an indication of exactly how far Officer Slager ran before he caught up with Mr. Scott,
It's certainly capable of providing that information, yes, sir.
so that the jury could judge the exhaustion, if there was any, that morning at the time that the fight or struggle began.
I'm not sure if the machine could level exhaustion levels, but as far as distance, it could, should be able to provide distance.
And the jury could make an assessment of somebody running that distance, fully geared, what their exhaustion level would be.
I'm sure they're capable of that, yes, sir.
Now, in that distance, was Officer Slager dressed in patrol uniform gear?
Did not see Officer Slager personally at the scene. The pictures that I know another agent had taken, I believe it was Agent Johnson, that she had taken, I believe showed him he had with his uniform. But I did not see him personally with his uniform on or with his gear on personally.
But based on the photographs that you have seen, you now know that he was, had his duty belt on.
Yeah, yes, sir.
And that's the duty belt that he was wearing in the struggle with Mr. Scott.
I would assume so, yes, sir.
And at the time of April 4th, his duty belt was not collected.
No, sir.
So any evidence on that duty belt of fiber evidence or fingerprints or DNA would not be available for this jury to assist them in their decisions in this case.
With regards to fingerprint evidence, I'm not sure if there would be much of the surface area of the duty belt would be for fingerprints. Possibly some of the other evidence could be there. There again, we do rely a lot when we're dealing with a situation like this for some of that information to be relayed to us. So therefore, if that was something that would be considered, then we would, they should, hopefully they would communicate that with us as well. Obviously, the agent that there should also be kind of visually inspecting as well as they're looking. That way, if they see something that stands out, they should trigger them to hopefully collect that.
But none of that evidence was collected until somebody realized that it might have some evidentiary value, and then it was collected days later,
I believe that's correct, yes, sir.
after it had been put back in supply and some of the items were redistributed to...
I'm not familiar with that much information.
Now, in terms of trace evidence, you're familiar with the collection of trace evidence?
Yes, sir.
Is it any more complicated than picking up a Post-it note and picking up trace evidence?
No, sir.
That's how you do it.
Yes, sir. That's one method.
What I just did now has trace evidence on this Post-it note.
Potentially.
None of that was done.
On
The duty belt, on the shirt, on the taser, on the whatever evidence you found out there.
Yeah, no, sir. No, sir. And there again, that is not something that we would do at the scene as well. That's something that would, with having the items, that would be done by a different department within the agency.
Whoever was responsible for doing that never did. On the scene, off the scene, in Columbia, in Charleston, at the warehouse, at the headquarters, nobody has ever done it. Correct?
Based on what you're telling me, I don't know. I don't know for a fact if that's true or not at this point.
I don't mean to tell you anything. I'm asking you if you know if it was ever done.
I do not know if that has been done or was ever done.
But
It
if
was
it
not
had-
done to my knowledge while I was there.
But if it had been done, you'd know it.
Not necessarily.
Now, did you inventory the 1990 Mercedes?
As I stated previously, I documented some of the findings that we found as we were searching through it. But there again, inventories are typically done on the law enforcement side of things where whoever's initiating the search warrant or having them towed, I believe they have to provide an inventory for the tow log from what I understand.
But for purposes of bringing data, information, observations to this jury who were deciding this case, did you or any other SLED agent inventory what was found in the 1990 Mercedes?
Yeah, an official inventory was not done by SLED. That's not something we routinely would do.
Did you inventory the police unit, the vehicle that Mr. Slager was operating that day?
The same manner as I described for Mr. Scott's vehicle would have been done the same way with Mr. Slager, Officer Slager's vehicle.
Did you look in Officer Slager's vehicle?
Yes, sir, we did. And I believe photographs were taken as well.
Was there a weapon, a long gun, a shotgun, or anything in the trunk of that vehicle?
I don't recall that at this particular moment. A visual or photograph would be more assisting me with that information.
Well, if a photograph,
If we have a photograph, that would assist me better with that.
just give me a moment.
Yes, sir.
Defense Exhibit 24. Is that the vehicle that was operated by Officer Slager on April 4th?
A better picture overall of it would probably assist me better, but this would appear, it appears the contents of the trunk appear similar, yes, sir.
Who took that picture?
Well, it was done by Agent Johnson.
In your presence?
Yes, sir.
Did you direct her to take a better picture?
No, it's one of those things at that point in time, she had been trained to a certain level to work independently in certain areas.
But it accurately reflects, for the benefit of this jury, what was in his trunk. Is that correct?
A certain portion of the trunk, yes, sir, in this photograph.
Is there a photograph that you took or was taken under your supervision that would better indicate what was in his trunk that day?
Without having the full array of photographs, I'm not sure I can answer that honestly at this time.
How about in your notes in front of you? Did you take notes of what was photographed and what wasn't?
I just have the vehicle listed here, so if the vehicle was listed, it wasn't anything that, in my particular notes, that indicate anything else.
Is there anything in this photograph, Defense 24, that suggests that there is a weapon of any type in the vehicle?
Other than it being a law enforcement vehicle, no, I don't see anything. Just in generally a law enforcement vehicle, I could assume that there is probably a long gun or another firearm or firearms-related evidence in this vehicle.
That's an assumption.
Yes, sir.
This is a murder trial. We don't assume.
Okay.
What is in the red bag?
Honestly, that appears to be a bag that would hold a Slim Jim type tool to like open vehicles with, or to assist in the opening of vehicles or unlocking of vehicles.
Did you look in the red bag?
I did not personally, no, sir.
Did anybody under your supervision look in the red bag?
I'm not aware of that, no, sir.
So if the solicitor may have imagined that there was a weapon in the trunk of that vehicle, that wouldn't be correct. Is that true?
Well, if you don't want me to make an assumption, I can't answer that honestly. I'm not sure.
Well, you're the one who was there. You're the one that examined it. You're the one that looked through the vehicle. Was there a long rifle in that vehicle?
I don't recall one, no, sir.
If there was one, you would recall, would you not?
I would hope so, yes, sir.
Tell the jury what a Slim Jim is.
As I explained before, it's a tool, a metal tool. Sometimes they come in multiple tools and in a case that looks very similar to this, and they're used to assist in people who are locked out of their vehicle or locked out of cars. They can be used to help you put a wedge in between the car door frame and the door itself, and use the wire tool, if you will, to try to help unlock to allow one to get inside a vehicle.
Not a weapon. correct?
It could be used as a weapon, but not typically.
The scan that you talked to about earlier, it was a Faro scan some 3 weeks later of the incident site. Is that correct?
Yes, sir, that's correct.
Was there a Faro scan of the 1990 Mercedes?
Yes, sir, there was.
And when was that taken?
I believe that same day.
April 23rd?
Let me look for my notes real quick, please, sir. Yes, sir, I'm showing April 23rd, yes, sir.
And how about the police unit? Was that Faro scanned as well?
A Ferris scan was done of a police unit, from what I understand, the same make and model, but we were advised at the time that Officer Slager's vehicle that he had was not available, so we had to use another one just to extrapolate that information.
Who advised you it was not available?
That was somebody from North Charleston Police Department, from what I understand.
Could you give us his name so we could?
I believe Agent Talon would have that information. He was, there again, he was kind of in charge of the Ferris scanning process.
The items that were removed from the Mercedes at the time of the search warrant, do you know what they were?
Give me 1 second, sir, please. Yes, sir, I'm showing there were 2 sets of keys. There was a set of keys from the center console and a set of keys from the ignition of the Mercedes.
Is that all?
Yes, sir, that's all I have in my notes that were taken from inside the vehicle.
How about the insurance card?
I know we took a photograph of it. I'm not sure if that was taken or not.
How about the insurance card?
There again, as I just said, I know we took a photograph. I'm not sure if it was taken or not. I don't have that in my notes as it being
How about the
taken.
registration card?
Same as you referred to the insurance card.
And where were those 3 cards taken from in the 1990 Mercedes?
I'm not sure. I know there again, a photograph was taken of where they should have been located.
Have you listened to the audio portion of the video that was taken by Officer Slager's car at the time of the stop?
I've heard it, but it's been a long time ago, so not recently enough to recall certain things from it.
Do you recall that there was a suggestion by the officer to the driver of the vehicle that they looked in their glove box?
No, I don't honestly specifically recall that.
You looked in the trunk of the 1990 Mercedes,
Yes, sir.
and you have indicated in previous testimony that you took the serial number of motorcycle parts.
We found a serial number, and that information, there was North Charleston officers present, and we relayed that to them.
I'm talking about what you did.
Yes, sir.
You testified that there were serial numbers.
Yes, sir.
Were there?
What I remember, I gave the information to the officer who ran it through their dispatch.
Have you since learned that there are not any serial numbers on motorcycle parts that were in the trunk of that vehicle?
No, sir, I'm not aware of that.
And if there aren't any serial numbers, your testimony regarding whether they were cleared by North Charleston, as you've testified, could not be correct.
If they're saying that that's true, then no. But I know numbers were provided to them. There was 2 items. There was motorcycle parts and also an Xbox that I believe that we had information on. So it's possibly, I know one thing was ran, if one thing I may have misspoke, but I know that we did run something through their NCIC, or that's Criminal Intelligence Center, Information Center, to see if it was stolen.
Now, with respect to the serial numbers that you've testified to, did you photograph those serial numbers?
I don't believe we did, honestly, no. Yes, sir.
I'll answer your question.
Yes, sir.
Good morning, Mr. Brown.
Good morning, sir.
As the principal crime scene investigator in this case, you were advised in your initial briefing that there had been a struggle between Officer Slager and Walter Scott. Is that correct?
Yes, sir, that would be correct.
Has that ever been an issue in this investigation?
Not that I'm aware of. It was not brought to my attention.
That's what Officer Slager said, correct?
I did not hear any statements or anything made by him directly, so I'm
That's what was reported to you,
correct.
and you took that as a fact, a given fact, correct?
Yes, sir. There again, as I stated in previous testimony, we have to take everything with context. So that's information that could be provided by witnesses, officers, other parties involved, and we can't give weight one more to the other. We have to consider all of it in context as we're evaluating what we're doing.
I understand that, and because that information had been provided to you, you had information that they had struggled over the taser, correct?
That is correct.
And what forensic testing did you have done with the taser?
Yes, so we had it swabbed for DNA.
Okay, and that decision I believe you said was made by Captain Neal.
Yeah, initially we had a group discussion. I believe it was myself, Agent Peterson, and Captain Neal. We discussed the matter. It was brought up about doing the fingerprinting and DNA, and then it was determined, Captain Neal thought it would be best if we work on the DNA. And there again, that comes from our lab kind of has a policy, the DNA department, when they want you to be able to pick, do you want DNA evidence, then you need to get DNA. If you want fingerprint evidence, then you need to go that route. They don't prefer to try to extract DNA after any fingerprint process has been
And
done.
do you know why that is?
There's different studies that are out there that show that you can get good DNA from sources after fingerprints, and there are also some that contradict that say it's not good to do so. And I think they err on the side of caution a little more.
And would you agree that it's more difficult to obtain touch DNA than DNA from a body fluid such as blood?
Yes, sir, I would agree with that.
Much more difficult, correct?
Yes, sir, it can be, yes, sir.
So do you think that that was an unreasonable decision made by Captain Neal?
No, sir, not at that time, no, sir.
And that was the only determination he made. Who made the determination of what to swab on that taser, what location?
That was done, I believe, by Agent Johnson when she swabbed the taser.
And that was done under your supervision, correct?
Correct, yes, sir.
I believe you testified on cross-examination that, it was your practice to swab various areas. Why did you not direct her to do that?
Because I wasn't standing right there at the time where she was actually doing it. So she was doing that while I was working on something else, essentially.
And is what she did incorrect?
No, it's kind of each his own. And honestly, our DNA department, when having dealt with them on other cases, they honestly would like, if you have an item, the more area or surface area you can swab of that item, they prefer it because they said the chance of actually extrapolating good DNA or a good amount of DNA to do a comparison for is greater than if you did not.
So she basically did or to process the taser for DNA as opposed to fingerprints and DNA was what the lab wants.
Correct, correct.
So was there any nefarious intent on y'all's part to not take taser?
No, sir, I don't believe so.
It was done in accordance with lab protocol.
Correct, sir.
Now, with getting back to this struggle, y'all processed the taser, correct?
Correct.
You examined Officer Slager's uniform,
Correct.
and when you do that, I assume you are looking for what?
Obviously, you're looking for anything that stands out, any kind of damage to the uniform, any kind of bodily fluids that could be on the uniform, anything there, again, based on the information we received. So we're looking for any information at the time that we had received showing that there was a physical struggle, any kind of injury that he may have had to himself, or injury to the other party that may have present itself upon those items.
And y'all did that, correct?
Correct.
And you did find blood in 2 locations, correct?
Yes, sir.
You did not find any damage to the uniform, correct?
No, sir.
You found some dirt, I believe, on left knee,
Correct. Yes, sir.
all indicative that possibly a struggle had occurred, correct?
Yes, sir.
What did you fail to do?
From my training, where we would stop our process, nothing. That's essentially where our process would stop. The items would have been stored, and they would have been up to someone else to make a decision to further process beyond that point.
And y'all also had pictures taken of Officer Slager to document any injuries that he may have had.
That is correct.
You took pictures of Mr. Scott to document injuries that he may have had, correct?
Yes, sir, that is correct.
And putting all this together, was there any question that there had been a struggle?
No, sir.
And what is the need of doing the trace evidence?
It could just be another added tool. It's just added information that can assist further if there was more transfer or anything of that nature that could have occurred that you couldn't visually see, just to further corroborate information that was already presented.
It's an uncontested fact that there was a struggle, correct?
I believe so, yes, sir.
And your examination of the uniform and your examination of Officer Slager and Mr. Scott indicated that there had been a struggle.
I would agree with that, yes, sir.
As you had put it, a struggle.
Yes, sir.
As opposed to a fight.
Yes, sir.
Now, I believe, and I may have just misheard you on cross-examination, I believe in response to a question from Mr. Savage, you indicated that you were aware that Officer Slager had made a claim that the taser had been used against him. Am I correct in that?
That is correct, yes, sir.
Could you please review your notes and show me in your notes where you were advised at any time that Officer Slager made a claim that he had been tased?
I don't have it in my notes that he had been tased. That information, I believe, came to us as we were working the scene. We knew that the first information we got, I believe, in our initial briefing was that...
Read your crime scene notes and tell me where it should say that Officer Slager claimed to have been tased.
Give me a moment, please, sir. In my notes, all I have that it states that, and I'm quoting from the notes, the officer and the victim got into a physical altercation over the taser, and at some point the victim gained control of the taser. And that's where my information stops.
So the fact of the matter is, you weren't provided information that the taser had been used against officers.
It's not in my notes, no, sir.
And when you searched the Mercedes afterwards with Agent Johnson, you were doing so for what purpose?
Initially, we're searching for, any evidence that could be related to what transpired, is anything that could have stood out as some kind of criminal activity that could have warranted the decedent fleeing on foot that led to the events that transpired.
In matter of fact, in your handwritten notes, you said would need to do a good search of suspect's vehicle. Is that correct?
Which notes are you referring to? Handwritten?
Your handwritten.
Okay. Give me a second, let me refer to this, please.
I believe on the third page.
I don't have that page in my notes here, sir.
Let me show you what I'm looking at and see if I got something that you don't have.
Okay.
I'm not trying to publish it to the jury, I'm just trying to verify the accuracy of the note.
What is it that you're handing him?
It's a copy of his handwritten notes, that presumably he has. He said he couldn't find this in his notes.
All right. You may proceed.
Do you have this page here, sir?
Let's see. Okay, actually, I do believe I have that one. Let me see if I can find it real quick. Page 306, yes, sir. Okay, I do have the page.
And this is what I'm referring about here.
Yes, where it says per Captain Neal, only photos of the vehicles needed and good search of the suspect's vehicle. Yes, sir. That's correct.
Because y'all were trying to find contraband, correct?
Yes, sir, correct.
Drugs or stolen property and all of that stuff.
Yes, sir.
Did you find any of it?
No, sir.
And the registration, do you recall whose name that car was registered in?
I do not at this time. No, sir.
We show you what's been marked as Defendant's Exhibit number 19.
Yep. Oh, sorry. Yes, sir.
And whose name is the car registered in?
Arthur L. Hayward.
And were you aware that he was actually the registered owner of that vehicle?
I believe we did, after we found this information, we were able to determine that.
And are you sure that there was insurance on him?
I'm not sure, as I said before, if there was and we photographed it, I would assume if we photographed it, we would have that information
Well,
provided.
you've reviewed the photographs in preparation of your testimony. Do you recall seeing a photograph of an insurance car?
Not that I'm aware of. There again, there was a lot of photos.
Thank you, Mr. Brown. I have nothing further.
Thank you, sir.
Anything further by the defense?
Considering the jury doesn't
Yes, sir, that is correct.
And a search warrant was granted by a magistrate judge for SLED to look through the Mercedes.
Yes, sir.
And law in the state of South Carolina requires the officer or officers who search a vehicle to make a return to that search warrant.
Yes, sir, correct.
And that's required by law.
Yes, sir, I believe so. Yes, sir.
And when a police officer searches anything pursuant to a search warrant, they are required to inventory those items taken.
That is correct. Yes, sir.
Can you tell us what that document is?
This would appear to be a copy of the return from one of the vehicles, a vehicle listed, so I'm not sure which vehicle, but it's appears to be inventory for, or I'm sorry, a return from a search warrant for one of the vehicles.
And which vehicle was it?
Based on the information that's listed here that was taken from it, I believe this would have been Mr. Scott's vehicle.
What is item number 3?
Item 3 says one vehicle insurance card.
Insurance company
Yes, sir.
for Mr. Scott's vehicle.
Yes, sir.
So what the solicitor was trying to ask you, that document's a court document, is it not?
It would appear so, yes, sir.
And the solicitor has had access to that court document for 18 months. Isn't that correct?
I would believe so, yes, sir.
And he tried to infer that there was no insurance card in that vehicle. Is that correct?
I'm not sure what he was inferring.
Now, the DNA, you indicated that it was not taken with multiple swabs because of some issue with the lab.
No, sir, that's not correct.
Well, I was confused about your testimony as whose decision it is in the process they used to obtain DNA.
There is a basic process that the DNA department prefers, utilizing a swab to extrapolate DNA. It is the individual agent who's doing the processing or collecting to DNA based on their training, how they were trained to do it, as to how they do it. As I expressed in my testimony, that's the way I had been trained many years ago when I started collecting DNA from various sources. That's the method I had used on firearms or anything that was similar to a firearm. I'm not sure if Agent Johnson was trained in that same way or that capacity.
But it would be your training and experience, and not contrary to SLED's lab, to obtain multiple Q-tip swabs on an instrument in which there was a question of possession. Is that correct?
That's my personal guidelines that I use, yes.
And it is approved, not discouraged, but an approved method of SLED's lab to take it that way. Is that correct?
Actually, I have to say it, I have been told that I took too many swabs before, so it could be.
Well, let's talk about the location of the swab. The business end of the taser that's in dispute as to whether it was used or not is the location to take the DNA, is it not?
It's one location that could be taken, correct, yes.
And who is the SLED scientist who evaluates DNA?
In this case, I believe it was Stewart or Sam.
And have you spoken to Agent Stewart?
No, sir.
So it would be Agent Stewart that could tell the jury about the laboratory view on DNA connection.
He could be better suited to answer that, yes, sir. There we go.
Any objection?
No, sir.
Submitted without objection.
Thank you.
Yes, sir.
Thank you. You may step down.
Your Honor, may I be excused from my subpoena?
Yes, you're excused.
Thank you.
Next witness.
State called Tracy Thrower.
As you come, we'll take a short break. Please go to the jury room. Please not discuss the case. Take a short recess.